Hi folks, today we're going to talk about adverse possession and what happens when the original owner is under a legal disability as the adverse possessor enters. So we're going to start with just a quick overview of adverse possession to make sure we're all on the same page as we talk about the special disability statutes. This is a diagram of adverse possession. So we start over here with an adverse possessor entering Blackacre. That's the trigger for the beginning of adverse possession. An adverse possessor, when they enter, is a trespasser. And the original owner has the right to eject the adverse possessor as a trespasser. And that right remains with the original owner throughout the statute of limitations period. Now, that period is going to be different in different states. For example, in New York, it is a 10-year statute of limitations period. In Virginia, it is a 15-year statute of limitations period. In Maryland, it is a 20-year period. So it matters what state you're in. And as a lawyer, you always have to make sure that you are checking the law of the specific state that the property is located in order to make sure you're using the correct statute of limitations. During the period of the statute of limitations, anytime along that period, O has the right to begin an ejectment action to eject A as a trespasser. Once that statutory period ends, however, two things happen. First of all, that's the moment when O, the original owner, loses the right to eject A as a trespasser, meaning that O no longer could come into court and bring a cause of action saying, hey, A is trespassing on my land, make them leave. And at the same time, A, the trespasser, acquires ownership of the property, title through adverse possession, sufficient to come into court him or herself and bring an action to quiet title, meaning to have the court recognize that the title now rests in A. So that's how adverse possession works. But what happens when that original owner is under a legal disability at the moment that the adverse possessor ends? Now, I want to emphasize before we talk about the two different approaches that states tend to take in answering this question, I want to emphasize that the phrase legal disability is highly specific. In the context of adverse possession, this framework that we're going to talk about for legal disabilities only applies to those disabilities identified in the adverse possession statutes or in the common law, depending on the state. The word disability does not have the colloquial definition that we give it, nor is it in any way related to what the Americans with Disabilities Act would define as a disability or what Social Security would define as disability. For purposes of adverse possession, the only legal disabilities that are relevant are minority, also called infancy, also meaning not yet being 18, not yet being an adult in terms of who's the owner, and insanity or incapacity, which has to be adjudged by a court, or in some states, imprisonment. So depending on the state, there are either 2 or 3 legal disabilities that will trigger this body of law we're talking about in the context of adverse possession. So if somebody, let's say, is blind or in a wheelchair or has something else that we in our colloquial speech would call a disability, or that might qualify somebody as a disability for purposes of benefits or special services, that doesn't matter. That is not a legal disability for the purposes of adverse possession. Again, the only disabilities that qualify for or as a legal disability for adverse possession are minority, right, when the owner is under the age of 18, insanity or incapacity, which is legally adjudged to be incapable of managing your own affairs, or in some states, imprisonment. Now, this is a diagram of one approach to how courts will address disability and adverse possession. We're going to call it the New York approach because it's the approach that's used in New York. hence the name. So again, we have A, our adverse possessor, entering Blackacre to begin adverse possession. And when A enters, at the very day that A enters, O, the original owner, is already under a disability. So the adverse possessor is entering against an owner suffering from a legal disability. And then we have our horizontal time axis, right? Time passes, and then we get to the point where the disability ends. Now, a disability can end one of two ways. It can either end when the person under the disability dies, so they're dead and they're not under a disability anymore, and the next owner takes the property, or when the disability resolves itself. So if somebody is a minor, when they turn 18, their disability of minority has ended and they are now an adult. Or if somebody is adjudged incompetent, they will either die without recovering, in which case their disability ends with death, or they will recover and be judged competent, in which case their disability has ended through recovery. So at the moment that the disability ends, that's a moment of choice. And we have to figure out what's going to happen then. We look at how much time has passed. Now, in New York, there's a 10-year, in New York, there's a 10-year statute of limitations for adverse possession. And there's an additional 3-year statute for disability. What that means is that when the disability ends, either through death or recovery, somebody can bring an action for the next 3 years to eject a trespasser. Now, this is a statute that is designed to help the person under the disability. It will never hurt them. It will never shorten the amount of time someone has left to bring an ejectment cause of action to evict a trespasser. So what do we do at the moment the disability ends? We look at the normal adverse possession statute of limitations and see how much time is left. If there are more than 3 years left on the normal statute of limitations, you just go with that. So if, let's say, an adverse possessor enters and O is under a disability, and the next year O dies, passing the property on to the next owner, at that point, there are still 9 years left on the statute of limitations in New York. So the new owner would be able to take advantage of the rest of that statute of limitations period to evict the adverse possessor. They would have 9 years because that's how many years are left on the adverse possession statute of limitations, the ordinary one. But if there are fewer than 3 years left on the normal statute of limitations, or if the normal statute of limitations has already expired at the time the disability ends, then the owner will be able to take advantage of the 3-year disability statute of limitations. So at the moment where the disability ends, either the owner will have 3 years under the disability statute, or we'll have whatever's left on the ordinary adverse possession statute if that is longer than 3 years. Again, the disability statute can only help an owner eject a trespasser. It never shortens the time. Now, that begs the question of what happens if the normal adverse possession period has ended and O is still under a disability. The adverse possessor can only quiet title 3 years after the disability ends. So this could go on for a very long period of time if an adverse possessor has entered property that is owned by somebody who is under a disability. Right? Ordinarily, it's a 10-year period. The courts figure 10, or the legislature figures 10 years is plenty of time for an owner to pay attention, notice a trespasser is there, and evict them. But if the owner is under a disability, the court says we're giving them some leeway, some special dispensation. So they have the normal 10-year statute of limitations under which they can evict a trespasser. But if it doesn't happen during that time, they will always have 3 years after the disability ends in a state that follows this New York approach. But it's not the only approach. So here's the other approach. It's the approach that's used in Virginia. Let me just add as a caveat at the beginning. One thing that makes this a little bit more complicated is that New York and Virginia have different statutes of limitation for ejecting an adverse possessor. As I said, in New York it's 10 years, and in Virginia it's 15 years. But that's an added wrinkle that doesn't have anything to do with this, what we're talking about right now, which is how the disability approach works. Okay, so pay attention to the conceptual differences rather than the numbers themselves. In Virginia, the statute of limitations for which an owner who is under a disability when an adverse possessor enters, the amount of time that owner has to eject the adverse possessor as a trespasser is told when the owner is under a disability. So that means, where in New York, right, you have the 10-year ordinary statute of limitations running throughout the whole time that the adverse possessor is there. In Virginia, the statute is told. It's stopped. It only is triggered when the disability ends. So there's a different moment of choice in Virginia because of the way it's structured. So in Virginia, the way this works is there again, just like in New York, there are 2 statute of limitations. There's the ordinary adverse possession statute of limitation, which is 15 years. And then there is the statute of repose, which is another statute of limitations that says under no circumstances can anyone bring a cause of action to eject a trespasser more than 25 years after that person enters. So the way this works in Virginia, instead of having the ordinary statute of limitations for adverse possession and then an added period that the original owner may or may not take advantage of depending on how much time is left on the original statute of limitations, here we look at how long has the adverse possessor been there when the disability ends. If the adverse possessor has been there for less than 10 years, then when the disability ends, just the ordinary 15-year statute of limitations for ejectment of a trespasser begins. If, on the other hand, the adverse possessor has been there for longer than 10 years, the original owner will have whatever is left of that 25-year statute of repose. This is because the courts are concerned and the legislature is concerned about having the ownership of property unsettled unpredictably far into the future. So there's an overall 25-year cap under which, regardless of whether somebody enters against an owner with a disability, this must be resolved. Basically, this approach extends the adverse, let me rephrase that. Basically, this approach will toll the statute of limitations, the adverse possession statute of limitations, for 10 years, for up to 10 years. And after that, after 10 years, the regular adverse possession period must begin, and at the end of that period, the adverse possessor will be able to quiet title. So, if the disability is removed in year 15, let's say, starting the 15-year adverse possession statute would then mean that the adverse possessor would have had to be in possession for 30 years before being able to quiet title. But the statute of repose cuts that down to 25 years. If the disability is removed in year 23, if the owner would have 2 years left in which to evict the trespasser. And if the disability is not removed within 25 years, the adverse possessor can claim title at the end of that period. So where the New York version is keyed to the removal of the disability, it has a shorter 10-year time period, but if the disability stretches for 40 years, right, the original owner or their successor in interest will have a short window, a 3-year window of time in which they can try to reclaim the property by ejecting the adverse possessor. Virginia has a different approach. It's just an overall time approach. It says, if somebody is under a disability when an adverse possessor enters, they will have up to 25 years. So it's two very different approaches. One is geared to when is the disability removed? That's the New York approach. And one is geared to, we're just going to define an overall period of time, and that's the Virginia approach. Now, don't worry too much about the details of this. First of all, were I to test you on this, I would give you the specific statute so you would know exactly what the rules are. This is just a conceptual understanding that there are two different ways to address this problem. Regardless of whether the New York approach or the Virginia approach is the one adopted in a state, right, the answer to this question is the same. What if O becomes disabled after A enters? Or if O's successor has a legal disability? We don't care. Okay? A enters against an owner. That owner is either under a disability when A enters or not. If the owner is under a disability when A enters, then these disability regimes will apply. If, on the other hand, the owner is not under a disability when A enters, we don't care if they later become legally disabled, because that will not affect adverse possession. Subsequent transfers of the land or subsequent disabilities are not relevant for purposes of figuring out when the adverse possession period will end and when an owner will lose the right to eject a trespasser and the adverse possessor will acquire a right to quiet title.